All right. Welcome back to another edition of Between Two FARS. I'm Warnke Miller here once again with the amazing Robert Tepfer. Bob and I are talking about ASBCA litigation, specifically witness preparation for depositions and hearings. We've talked to you a little bit about the basics of getting to know your witness, telling them to tell the truth, and emotionally preparing your witness for testimony. But we'd like to talk a little bit more about the mechanics of witness testimony, sort of give you the functional aspects and details that you want to provide to your witness. Bob, what are some of those real just functional day-to-day, hey, this is what you need to know about the process procedure tips that you give to your witnesses?
I explain to the witness, look, listen if I object to what I'm saying. You'll most likely have to answer, unless it's attorney-client privilege. You know, they have broad leeway, but it puts it in context. If I object and say the question's ambiguous, you know, need to be more specific, one of two things you can do. You can either think very carefully about the answer, which you should anyway, but speak to it in a sense of needing clarity, or ask for that clarity, or simply say, I don't understand. Sometimes that folks think that because a lawyer has asked them that they should answer it and that they've done an adequate job. And you have to explain to them that the lawyer will bait you and effectively ask, ambiguous questions to see if they get specific answers and maybe surprise themselves. They didn't know about a certain thing. Yeah. If the question is, an and question or an or question, object immediately and ask that counsel be specific as to what they're really inquiring about. Ask if the terms are ambiguous. If it requires a conclusion of law, object to it. The witness needs to be listening to all that, and so that they can lean back and say, well, I'm not a lawyer. I'm really not sure what you mean by that. And you prepare them for that role so that the testimony is more focused, that they're educated as the case ends unfolding in the deposition, and that they are listening. And we've discussed at length how they need to wait a few seconds to answer. Counsel may try to encourage them to get kind of an impulsive response. Tell them that there's nothing wrong with saying, I don't understand what you're saying. I don't know what you mean. Be careful of being led, saying, you use this adjective or that time frame, and I'm not certain of either one or both. Okay. Yeah. They will attempt to, you swore under oath that this occurred on the 27th and that you were with these three people. And, they don't need to feel like that's the end of it. But if they set up a prior question to that effect, they need to understand it's a little bit difficult to go back and say, well, all those people weren't there. I'm not sure it happened on the 27th. Well, what other aspects of your testimony that you've given today are you uncertain of? They need to understand that their credibility is at stake to the extent that they write them a blank check, that they tell them, yeah, it's a yes, when you can be absolutely certain that the way the question was phrased put their case in the best possible light.
Now, for potential witnesses who might be watching this, it's important to understand that opposing counsel, whether this is in a deposition or in the hearing, will ask you a question, and then you're going to be responding to the question. But if you, like Bob said, pause before you answer the question, that gives you a chance to get your own thoughts collected. It also gives the attorney a chance to object. Now, objections are important because in a deposition, it's preserving the issue so that later on, if we, as the government attorneys, don't think that that information that came out during the deposition should be admissible in court, should be used as evidence against the government, by objecting during the deposition, even if you're asked to answer the question afterwards, we've registered the fact that we don't think this is an appropriate question and therefore the answer should not be considered evidence. In hearing, objections, even if they're overruled by the judge, ideally you would want the judge to grant your objection so that the testimony doesn't have to be given and you don't have to answer the question. But even for those times when you're overruled and the witness is required to answer, the objections are still important because that can form a basis for appeal later on if you're wanting to challenge the decision that the judge made in this case. So it is important to listen to the objections, the way Bob said, to sort of understand why this is an issue. And that also gives you some time to think through how you're going to answer the question if you're required to.
I think we've spoken before about how the rules with regard to an ASBCA case, they're a spectrum, and the judge can permit hearsay, or they can embrace the federal rules very strictly and elect not to. But even if they are willing to hear the testimony and you've objected very strenuously, it can go to the weight that's to be given. And so even if you objected to it at the deposition and subsequently it's brought in, you can state that, consistent with the objection at the deposition, and again at hearing, it's an opinion. He's clearly not an expert in this area, wasn't qualified, could never have been qualified, and the weight accorded to it should be, consistent with that.
Let's talk a little bit about documents and the preparation of your witnesses, what documents they're looking at before they go in to testify, what they bring with them to testify. What do you tell them, Bob?
Well, obviously they're going to ask you, what did you look at in preparation for your testimony today? And you tell the witness in witness prep, they're going to do that. So if there's something that you have, personal diaries, or what you thought was personal at home, whatever, guess what? That's going to be the next discovery request. And, that's not going to necessarily be fun because I don't even know that it exists, potentially. Now, the easiest thing to do is say, you know what, you've got all these binders from the Rule 4 file. They're already admitted into evidence, they haven't been objected to yet. And the fact of the matter is you can look at all of them. If there's documents that are outside the Rule 4 file, I want to know about it now.
Yes.
And, I want to know it before you get in there. You don't want any surprises. You don't want to be struggling with what does that document say when your witness is being deposed and you have no idea what's going to happen next. That's not any fun. The whole point of discovery from the other side, they're very ethically obligated to ask is what's out there? What do you have for a case? In a civil context, hopefully it leads in a judicial economy context to more settlements. Because if we can all look at everything, maybe we can agree to a settlement or agree to withdraw the case or make full payment. So they're not doing anything bad or evil, but you ought to know about it. And your witnesses need to tell you up front.
Yeah, the nice thing about ASBCA litigation is the Rule 4 file. All of the evidence for the case is right there in that file. It's an electronic file these days, so it's easy enough to give access to all your witnesses. And if you're a witness preparing for hearing, go through that Rule 4 file. And if there's anything outside that file that you think you need to look at in order to be prepared to testify, you need to notify the government attorney right away, because that's going to be an important aspect. You don't want to find out there's more evidence out there than has already been admitted into the Rule 4 file. Any other functional tips that you can think of that are important for witnesses to understand?
No, I do believe in getting a lot of the folks together initially, because you'd be amazed at what you find, what ultimately needs to go into the Rule 4 file, what they might want to be looking at, but you want to know about and be in the Rule 4 file in preparation for deposition. And that, you can kind of put the case together as early as possible, as opposed to being surprised by your own witnesses early on. That's just absolutely no fun. The whole concept of civil discovery is to eliminate surprise.
Yes.
The whole, and part of that is knowing your witnesses and having an idea as to what they're going to attest to and how they're going to fit together. And that's part of prep. All the prep is not instructions to the witnesses. It's getting an understanding of their personalities, their knowledge of the facts and the roles that they played. And that takes time. So if you heard about somebody, if you talked about them on the phone and you wait until a day before deposition to start preparing them and learning about them, you may have waited too long.
Yes, yes. Well, we really appreciate you joining us for this stroll through witness preparation. But as we said in the first episode, each situation is unique, and you need to listen to the attorney who has been assigned to your case, government attorney who is helping prepare the government's position, and any instructions or directions that they're giving to you that is going to be specifically applicable to your testimony and to your case. Thanks for joining us on Between Two FARS.